in on a particular crisis, a particular moment that's coming up, where we are seeing the way that this court, this Roberts Court, has been trying to regress our rights, reverse our rights, and do so in ways that I myself consider to be illegitimate. Today, what we've done is bring together amazing experts in the field to talk with reporters and others about what's at stake and what people can do in response to the decision that the court is getting ready to issue in Louisiana versus Calais. Before I jump into introducing our panelists, and I'll introduce them one by one and have them make their presentations to you, I just want to say from my perspective, from our perspective at Court Accountability, we think it's vital for the American people to understand when this court acts not as a so-called conservative court, but in ways that are illegitimate in our democratic process. And what we've seen from this Roberts Court on voting rights, beginning with the Shelby County case over a decade ago, is the use of the Supreme Court by John Roberts and his fellow Republican appointees to take down, to limit the ability of Congress and the American people to protect voting rights. When John Roberts orchestrated that decision in Shelby County, it unleashed a wave of voter suppression measures. It disregarded thousands of pages of factual finding by Congress on the reauthorization of Section 4 and Section 5 of the Voting Rights Act. And now here we are in 2026 with John Roberts and his cohorts poised to destroy the effective enforcement mechanisms of Section 2 of the Voting Rights Act, which, as I detail in my book, Without Precedent, John Roberts has been gunning for since he first began his career at the Justice Department, targeting Section 2 of the Voting Rights Act and the important role that provision and the related cases make for ensuring that the Black vote in America is not diluted. So we are right now preparing for that ruling. We don't know when that ruling is going to come down. I'm sure none of you do either. But one thing that is clear to me is that this will be another ruling by this Roberts Court that limits the power of the Voting Rights Act in ways that I consider to be illegitimate. And that's one of the reasons why, for court accountability, we think that efforts to repair the Voting Rights Act, to restore the Voting Rights Act in the face of these actions by the Supreme Court, by the Roberts Court, to expand voting rights so that voting is easier in America, not harder, not more restricted, needs to be paired with court reform, because this court has shown its determination to make it harder for Americans to vote, and in fact, make it harder, in particular, for Black Americans to have fair and full representation in our democracy. And that is something we must contest, we cannot normalize, and we must work together, arm in arm, to expose and to reform. So that's my opening, and I'm going to not do much speaking from here on out because I really want you to hear from our amazing panel of experts. We have, to start out, we have Mitchell Brown. He's the senior counsel in the voting rights section for the Southern Coalition for Social Justice, and he's a SOLVE, a Solve Network coordinator. Mitchell brings deep expertise on Section 2 litigation, regional coordination among more than 300 organizations who are working on voting rights, redistricting, and census engagement, and has particular expertise in North Carolina, but the overall landscape of the Voting Rights Act and what we're seeing from this court. So, Mitchell, can you please join us now and share your thoughts on what the Louisiana versus Calais case is all about? Can you help connect that to Allen versus Milligan, to that litigation, and also really explain the stakes, why Section 2 matters so much?
Absolutely. Thank you so much, Lisa. As Lisa said, I'm the coordinator for the Solve Network. Solve stands for Southern Leadership for Voter Engagement. And our story really begins after the Shelby County decision that Lisa mentioned just moments ago. In 2014, we were founded as a way to keep Southern organizations together and at the table talking about how to fight back against voter suppression because we no longer had, the pre-clearance provisions of the Voting Rights Act. And so this the VRA is very important and has been very important to Black and brown voters across the country, but mainly in the South, since it was passed in 1965. The reason why it was passed in the first place is because Black voters did not have voting rights. We may have had certain rights under the Civil Rights Act of 1964, but we weren't able to effectuate our voting rights until the passage of the Voting Rights Act in 1965. And so this Louisiana versus Calais case is honestly a continuation of the terrible racist history of the South in an attempt to retrench white power when black voters have received some semblance of power, which black voters did over time. And so in Louisiana versus Calais, the case is about Louisianans wanting a second majority black district. And why that's important is because under Section 2 of the Voting Rights Act, the statute says that voters have to have an opportunity, equal opportunity to engage in the political process. We can't do that if we have districts that substantially shut out a certain percentage of voters in a state and don't allow them to let their voices be heard. And so Louisianans have been fighting for this district for decades, and they finally got it. They finally got it, but not because the Louisiana legislature decided to do it, but because there was a court case that said, hey, you might violate Section 2 of the Voting Rights Act if you don't draw the second black district. So the legislature drew the district, and that district went into effect. But then there's a group of other voters, and they call themselves non-black voters, who said, hey, not so fast. This district is a racial gerrymander. And for those who are not familiar with racial gerrymandering, that just means that race was the predominant factor or the main factor in drawing a district. And so these voters brought this case saying, hey, the second majority black district was only drawn because it wanted to collect black people. And the court, the three-judge panel in the Western District of Louisiana and one Fifth Circuit judge agreed with that. The Fifth Circuit judge, dissented on the original opinion, but it went up to the Supreme Court, and now the court has before it the question of does compliance with the Voting Rights Act, necessarily comport with compliance with the U.S. Constitution, especially when it comes to drawing districts that may have some racial considerations within them. And so that's really the background of Louisiana versus Calais. It is a very, very important case in making sure that Black Louisianans have, equal opportunity to access, the political process. And this is very similar to the Milligan case that was just 2 years ago, where the Supreme Court upheld, a ruling that Alabama had to draw a second majority Black congressional district, again, to make sure that Black Alabamians had an equal opportunity to, engage with the political process. The Supreme Court upheld that in 2023. In 2025, there was a full trial on the merits, and the court found that not only did the Alabama violate Section 2, but they also intentionally discriminated against Black voters by not drawing this district. Alabama was the word my dad uses hard-headed, stubborn. They didn't want to draw this district, and they said, "Court, make us," and the court did. And so now Alabama has a second majority Black district. But the way these two cases intersect is because the court is dealing with a similar question: do racial considerations, in drawing a map, violate, if you draw a map to comply with Section 2 of the Voting Rights Act, does it violate the Constitution? That question wasn't necessarily raised in Milligan, which I think is the difference between Milligan and Calais, is now this question is squarely before the court of, if I draw a district because I'm going to comply with the Voting Rights Act, but I draw it when race is a factor, am I racially gerrymandering this district? And so that's what's before the court now, and that's how Allen and Calais are interconnected. The concern that I have with this is that the court upheld, in upholding the Milligan case, said that racial considerations can be a part of drawing a district. Now they are trying to backtrack that essentially, and they're using, the guise of compliance with the Constitution, to cloud or allow them to try to rewrite their opinion in Milligan. It's really a second bite at the apple of answering that question. And so, the concern is, and to go back a step, like this conversation has happened before in other contexts, and specifically in North Carolina, where states have drawn maps and districts to comply with the Voting Rights Act, but then have been shot down, by the courts, because they didn't need to do it or they did it for a racial purpose or this whole conversation about racial purpose and what can be considered in drawing a district is the important question that is before the court now. And so if the court comes down and agrees with the plaintiffs in the racial gerrymandering case that this district, the second majority black district, is in fact a racial gerrymander. The court finds that you can't take into consideration race in drawing a district. Section 2 may go away. And if Section 2 no longer, or it may not be useful, I will say. And if Section 2 is no longer useful, then the Voting Rights Act really becomes a nullity. And our tools to fight back against inequitable mapping and unfair mapping are very, very limited. There are three main ways that you challenge a map. One is intentional discrimination, the second is racial gerrymandering, and the third is under the Voting Rights Act. Racial gerrymandering jurisprudence was limited in 2024 under the South Carolina NAACP versus Alexander case, where the Supreme Court found that the South Carolina legislature moved black voters to another district, not because they were black, but because they were Democrats. And so the partisan nature of that move, of that redraw, was greater than the racial considerations. And so now we have, it's very hard to bring a racial gerrymandering case, which is ironic because it's a racial gerrymandering case, but it's cloaked in, denying again black voters the ability to let their voices be heard. And so we don't have racial gerrymandering cases are hard to bring. In the Voting Rights Act, if this goes down in Calais, where we don't have that tool anymore, that really leaves intentional discrimination, which is a very hard case to bring because you need direct evidence, or if you have circumstantial evidence, you have to have a lot of it in order to convince a court. And especially in this partisan day and age, where a legislature can say, I drew this map for partisan reasons, that wins the day for the court. That's concerning because many times that partisanship is just racism cloaked as partisanship. And so we have to fight back against that. And so that's why this case is so very, very important. And I know I'm coming to the end of my initial remarks. That's why Solve and Alabama Values are going to be working over the next couple months to a year around talking about the Calais case and the outcomes of the Calais case and the impact of the Calais case on local and state voters, because that's where we see a big potential harm is on the local level, where school boards, city councils, will see this if the case comes down unfavorably. These local boards will see it as an opportunity to eliminate majority black districts or majority brown districts, and say we don't have to follow that. We can draw districts, and we can't take into consideration race. Which is going to end up harming black and brown voters. And so we're going to be working on a narrative and educational campaign over the next couple of months to a year, really focusing on state and local level actors and trying to make sure that those voices are heard. And Lisa, I'll turn it back to you.
Thank you so much, Mitchell. Thank you for that great introduction. I just want to add quickly on that question of Section 2. One of the reasons why we're at this point is because John Roberts lost the battle in the early 1980s when Congress was determined to fix a Supreme Court ruling coming out of Mobile, Alabama, in which the Supreme Court tried to impose intent only, basically as the basis for having a Section 2 violation. John Roberts fought for months and months to try to prevent that reform. He lost. And so effects can be taken into account. The effect of diluting votes can be taken into account. And now we see this Roberts Court asserting in various ways color blindness in response to a law that was written precisely because America is not colorblind, because voting has not been treated as a colorblind issue. And in fact, for years, for decades, and including in the past decade, these legislatures have been continuing to behave in ways that are not colorblind, like in Milligan with the Alabama redistricting, and like in this very case, where even though African Americans represent more than 30% of the population in Louisiana, that white majority Louisiana legislature created a congressional map that was 5 white majority districts and only 1 black majority district. And as Mitchell points out, the downstream effects of this court, the Roberts Court, intervening here is not just on our congressional delegations and trying to bleach out the congressional delegations of the South, but also bleach out Black representation, Black and brown representation across the board, school boards, counties, cities, and states. So, without further ado, let me turn this over to Amir Badat. He is a voting rights attorney with and he is the Southern States Director and Senior Advisor for Fair Fight Action. Amir brings on-the-ground experience in confronting voter suppression, redistricting abuses, and electoral barriers across the southern states. And he's going to talk a bit about the impact of these Supreme Court rulings on voters. He's going to talk about voter suppression trends and also situate this all within the broader Southern patterns we've been seeing coming out of these legislatures targeting, making it harder for Black Americans, Black and brown Americans to vote. So you've got the floor.
Thanks so much, Lisa. Really appreciate you. And really appreciate the excellent background that Mitchell just provided on Calais and what's at stake in this lawsuit. It is incredibly important. It could, make our Congress potentially a one-party Congress. It could eliminate up to 140 Black majority districts across the South. And these are not just numbers. Oftentimes when we talk about redistricting, we get really caught up in kind of the technical aspects of redistricting. We talk about maps, we talk about percentages and demographics and boundaries, and it all feels oftentimes very abstract. But what is really at stake here and what redistricting is really about is it's about people, and it's about the power of people to have a say in how they are governed. How the boundaries of a particular district are drawn impacts a person's political power and the extent to which that person's voice is incorporated into the political process. And that's really what Section 2 is all about. Section 2 looks at the extent to which the minority voters have an equal opportunity to participate in the political process. And so what we're talking about when we're talking about redistricting is how can a particular person living in a particular jurisdiction actually influence the outcomes that they have in their lives, the way that their government works. And I think, looking at some of the cases that are currently pending and some of the things that have been talked about in courts by voters who have brought these cases, I think is really instructive in helping us understand what it is like, well, how Calais really could impact the lived experience of voters on the ground. We actually have a lawsuit that is going to trial next week, a Section 2 lawsuit related to DeSoto County, Mississippi's county redistricting map. And so we've talked about how Section 2 applies not only to congressional districts and state legislative districts, but also to local districts. Your county board of supervisors, your election commission, your school board, your city council, they are all governed by Section 2. And what the DeSoto County case has to do with is the county Board of Supervisors map, which also governs 4 other elected bodies. And after the 2020 census, DeSoto County, which is a county that has a third Black population, drew its map so that Black voters could not elect a candidate of choice in any one of the 25 districts or 25 seats that are governed by that map. And so every single elected official under this map currently elected is white. And that's been the case for a long time in DeSoto County. And so this trial that's moving forward on Tuesday, there are individuals who have participated in this lawsuit, residents of DeSoto County, Black residents of DeSoto County, that have talked about what the impact is like living in a county where Black people have zero representation at the county level. Like I said, DeSoto is a third Black, but Black people make up 70% of the juvenile arrests. Black children are arrested at a highly disproportionate rate. Black people are almost 60% of the population that live in poverty. And when you hear stories from people on the ground in DeSoto County who are living under these conditions, and you hear about how they attempt to address their Board of Supervisors or their election commission, they try to ask and make demands for those bodies to implement policies that actually work for Black communities. hearing those stories about how it feels like it's like banging your head against the wall because there's no representation at the county level. There aren't representatives who are taking into account the interests of Black communities across the county. I think that is exactly what we face when we're thinking about the potential impacts of Calais, because right now we have Section 2, which, we're going to move forward next week with this trial and hopefully succeed. And if we succeed, we'll have a remedy, which includes drawing a district where Black voters would be able to elect a candidate of choice to these bodies. But without Section 2, the current circumstances, the status quo continues and likely gets worse in a place like DeSoto. And that's true all the way up as well. When you look at state legislative districts, when you look at congressional districts, the lack of representation has real consequences. And what we've seen since the Voting Rights Act was passed in 1965 is that Black elected officials and officials that represent opportunity districts under Section 2 are often at the forefront of some of the most important policy battles, whether they have to do with access to health care, whether they have to do with economic justice or voting rights. Oftentimes, our elected officials who represent voters of color are the vanguard in those fights. And what is at stake with a decision that might gut Section 2 is that we will have fewer of those leaders in each of these elected bodies. And that has real policy implications for everyone, not just voters of color, but all Americans around the country. And so what we're seeing across the southern states in the context of redistricting and voter suppression patterns over the past, let's say, 5 to 6 years since the 2020 election and 2020 census, just during this redistricting cycle, we've seen redistricting claims brought in courts in every single southern state under the VRA, under the 14th Amendment, the claims that Mitchell was talking about. We've seen those claims brought in every single southern state, challenging state maps, congressional maps, as well as local maps like the one in DeSoto County. And what that tells us is that discriminatory redistricting is still very much happening. It is a current phenomenon. It is not something of the past. And some of this has to do with the fact that Section 5 was gutted in Shelby County versus Holder. And so you didn't have that ex ante check on state and local jurisdictions from adopting discriminatory maps. And so we had to use Section 2 to be able to challenge those maps after they were already adopted. And that's one of the implications of not having Section 5 anymore. And now what we're seeing in the context of Calais is that southern state elected officials are not only talking about what they might do if Section 2 is gutted, but they're already taking action. In states like Alabama, the legislature has considered legislation to move deadlines. They moved the qualifying deadline in Louisiana. In Florida, Governor DeSantis has already called a special session in April specifically to give the Supreme Court more time to make its decision so that the state can adopt a new map before the midterm elections take place in 2026. And so we're seeing southern state elected officials gearing up for a potential decision in Calais. And that's something that we have to be ready to fight back against if we do get that decision. We'll talk about that a little bit more. And then what we're also seeing, along with discriminatory redistricting, we're also seeing voter suppression bills getting passed across state legislatures. Since 2020, there was an explosion of voter suppression legislation introduced not only in the South, across the entire country, and enacted in many states across the entire country. And some of the things that we're seeing at the federal level related to documentary proof of citizenship and the SAVE Act, we're seeing the same type of legislation being introduced at the state level. We're seeing documentary proof of citizenship bills being considered. We're seeing restrictions on mail ballots and early voting being considered and enacted in many states. And in conjunction with the impacts that we're seeing on the redistricting front, in conjunction with how difficult it already has been because of the Supreme Court and in the Brnovich case to bring Section 2 claims against voter suppression bills, that's a serious threat. And we have to consider all of this taken together. It's not just one individual thing happening independently of everything else. We're seeing a coordinated attack on the ability of our democracy to work, and in particular on the ability of Black and brown voters to exercise their political rights and have their voices heard at every single level of government. And so, what does it mean? What would it mean if Section 2 is further weakened in the Calais decision? And in particular, what does it mean for our organizing and electoral participation efforts heading into future electoral cycles? The simple answer to that is that it makes it harder. When there are fewer districts where Black voters or other voters of color can elect their candidates of choice, what that means is that it's going to be less likely for elected officials who are the preferred officials of Black voters or voters of color. They're going to be less likely to compete in elections. They're going to be less likely to run campaigns. That means we're going to have more races likely that are uncontested. And that means that there are going to be fewer resources coming into those areas for organizing, for civic engagement, to actually try to turn people out and engage people in the political process. It becomes really, really hard to get that work done. And what I fear is that in many states, particularly in the South, if you see discriminatory redistricting happen in a post Section 2 world, you will see that the areas of each of these states where Black candidates can be competitive, it's going to shrink. And what that will mean is that our organizing and electoral participation work is also going to shrink in many of those areas. But that said, that work will become so much more important. And what I think is important for us to realize, particularly in this world in which we have courts that are hostile to civil rights and to voting rights, and where we cannot rely on the courts to be our saviors in terms of protecting these rights, we have to use all of the tools in our toolbox. We have to remember how important organizing is, and we have to think about organizing as one of the most, if not the most important tool in getting people engaged and building political power. And we also have to remember how important public pressure and media coverage and communications are in moments like this. Like I said, we cannot rely on the courts to protect these rights in this particular political environment. So we have to leverage tools like communications, messaging, organizing, and public pressure. Those are going to be the ways that we have to build power, and those are going to be the tools that we rely on to build power in a post Section 2 world. And so I'll pause there and turn it back over to you, Lisa, and happy to take any questions.
Thanks, Amir. Thank you so much. Your description of the on-the-ground effects, I think, is just really powerful, so powerful to underscore. It reminds me very much of the congressional findings after that City of Mobile case versus Bolden, where Thurgood Marshall dissented in that case because, as he noted in that decision, the right to vote could be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as it can by wholly prohibiting the effectuation of the right to vote. And we saw in that Mobile County case, and Congress found that when the people of Mobile, Alabama, when Blacks did not have representation, their streets weren't paved. City services weren't delivered. So the right to vote is obviously a gateway vote for securing other rights, including material rights, just to have basic rights in our communities, as you point out, in terms of the way law enforcement may be used in a discriminatory fashion, the way that policies may entrench poverty, and more. And so it's the right to vote along with all the rights that representation helps secure. And so I'm so delighted and honored also to introduce to this audience, the reporters who've come today, someone who was instrumental in organizing this panel, Anisha Hardy. She is the executive director of Alabama Votes and Alabama Values Progress. She brings a tremendous narrative and cultural strategy lens situating redistricting and court decisions within the longer arc of Southern political history, meaning making and public stories shaping democracy as we come in for the 250th anniversary here. Anisha, your leadership and work along with your panelists, I'm so glad that you could be here today on this panel. You've got the floor.
Thank you, Lisa, and thank you to Court Accountability and also the Solve Network and Fair Fight Action, and also my team at Alabama Values for convening this conversation. And also thank you to the media representatives that have joined. I really hope that you take what you hear today and use it to frame this moment for the communities that consider you, a trusted messenger. So I want to start by grounding us in something that often gets overlooked in the mainstream discourse around legal conversations, especially around redistricting cases. These cases are not just about maps. This is not just about legal doctrine. These cases are not just about Section 2 litigation. They are about stories. They are about whose story counts, whose community is recognized, whose political identity is considered legitimate, and whose voice is, diluted, fractured, or even worse, erased. And so when people hear, a case name like Louisiana versus Calais, it can feel abstract. But as someone who examines how people make meaning of cultural and political moments, I've come to learn that, narrative and messaging is what translate that abstraction into the lived reality of folks. And the media and citizen journalists and influencers and community leaders and elected officials have the power to shape the narrative. Ultimately shaping how, the public understands what, this case is actually about. Is it about, technical map drawing, or is it about Black political power in the South? Is it about judicial, overreach? Or is it about whether communities who have endured generations of disenfranchisement and are allowed to have meaningful representation? And so the fight here is not just about, districts, it's really about meaning, and meaning really determines the legitimacy. And I want to point out that historically, meaning making has always shaped the trajectory of democracy, and especially in a region like the South. Laws were written, but certain stories made them acceptable in the public. Certain court rulings were issued, but it was the narratives around those rulings that determined whether communities saw the rulings as a protection or punishment. When we think about from Reconstruction to Jim Crow to modern voting rights era, what people believed about power and about their belonging to democracy and legitimacy shaped how they responded to policy into one another. Right, we see that today. And so I often say that people don't move based on legal text alone. They move based on inherited memory and cultural identity and their faith traditions and, the stories that are passed down in families and their lived experience. And so the meaning attached to a ruling like this, whether, it signals protection, portrayal, or threat, is filtered through those deeper layers. And if people are convinced that redistricting challenges are partisan maneuvering, right, then attacks on Section 2 can feel procedural, but it's not. If people understand them as part of a decades-long effort to narrow the political, voices of Black communities, then this moment looks and it feels very different. And that is why, we have to connect the dots for folks. We have to help people make meaning of this moment. I say that, our democracy has always been fragile, in part because of its foundation, a foundation that, excluded and required struggle to expand. It has never been self-sustaining. And so it has always required this type of pressure that Amir talked about, this type of public pressure, this participation, this protection. And so what we're watching right now is not this sudden collapse of democracy, but this visible strain of a long-standing fault line. And if we are on the verge of seeing the core democratic protections erode, it's going to take all of us. It's going to take the organizers. It's going to take the journalists. It's going to take the legal advocates, to really hold the line. And so I want to talk a little bit about how, court decisions fit into the longer arc of voter suppression in the South, because we cannot talk about this case without placing it in historical context. And I think that's important for folks to understand that the South has always been a testing ground for voter suppression strategies. The poll taxes, the literacy test, the racial gerrymandering. Each generation repackages the strategies, but the language shifts, right? The justification shifts. But the underlying goal remains the same: to dilute Black political power while maintaining the appearance of legality. And so I mentioned, the Reconstruction, the language that was used there for the poll taxes was protecting the integrity of the ballot. We're seeing a lot of laws being passed now under the guise of election integrity. And more recent, we were hearing language about colorblindness, race neutral principles used to push back against solutions like Section 2, right, that was meant to address discrimination. And we hear concerns about partisanship when communities of color seek fair representation. And so we're watching this terminology evolve: election integrity, administration, administrative efficiency, traditional districting criteria. And so I think it's important for people to understand that the strategy adapts to the legal moment, but the through line is consistent. And so we saw that clearly. I think someone mentioned Shelby v. Holder. Lisa, I'm glad you mentioned that. But we saw that, Shelby v. Holder in 2013, when the Supreme Court struck down the pre-clearance formula, right, of the Voting Rights Act. And overnight, states with long histories of discrimination were no longer required to get federal approval for their changes. And almost immediately, we saw the street voter ID laws. We saw, the polling places closing. We saw all of this. And so Section 2 of the Voting Rights Act is one of the most powerful tools left in the Voting Rights Act. And I think people need to understand that. It is one of the most powerful tools that communities have to challenge discriminatory maps. And so we saw the strength right here in Alabama with the Supreme Court case. We saw how communities organized, how they fought to secure the second majority district. And so what is at stake in Calais is whether that tool remains meaningful. And so when the legal terrain shifts, it doesn't happen in isolation, it fits into a pattern. And so, the media and advocates and organizers and the public, they need to understand that pattern. We have to close the knowledge gap around, the historical context with this issue, because this should not be framed as a partisan issue. Fair representation is not a Democratic issue. It is not a Republican issue. It is a democracy issue. The right to have, your community fairly represented, to have your vote carry, weight, to be able to challenge discriminatory maps, those are structural protections. That's not a party platform. And I think we need to start framing it that way. So when this conversation gets reduced to red versus, blue, we lose sight of what is actually at stake here. And this is about whether, rules are applied fairly, and whether people have access to power, whether as we're approaching the 250th, whether the promises written into law mean something in practice. And so if we allow it to be flattened into partisanship, we really narrow that moral frame. But if we name it for what it is, a fight over whether everyone really gets a fair say in democracy, then we invite everyone, regardless of party affiliation, to see their stake, in the outcome. And as this case unfolds, I mentioned that we are approaching the 250th anniversary of this nation. And what we are seeing nationally is a surge of this nostalgia-driven rhetoric about American, democracy. Language about the founding principles, colorblindness, restoring order, protecting integrity. And I often say that type of rhetoric can function as a narrative camouflage. Like, it really romanticizes a version of democracy that never included everyone. It centers a story about freedom and fairness while leaving out the reality that at this country's founding, Black people were enslaved, Indigenous people were displaced, women could not vote, and property ownership determined political voice. And so this democracy was, at its inception, was always built for white land-owning men. And when we romanticize that era without naming those exclusions, we really normalize a version of democracy that was narrow by design and uneven in practice. And so that selective memory makes it easier to defend present day restrictions as tradition, rather than recognize them as part of this longer struggle over who fully belongs in a democratic process. And so when courts invoke tradition without interrogating who that tradition excluded, it narrows our democracy. And when people hear that, democracy is being protected without a historical grounding, they may not recognize that protections are being dismantled. And at the same time, like I said, this country is becoming more diverse in every way, racially, ethnically, culturally, politically. Communities are growing, coalitions are shifting. The younger generation, they're asking different questions about power and identity. And so people are at this moment reimagining democracy. They are envisioning and demanding a democracy that reflects all of us and not just some of us. And so, a democracy that is multicultural, multiracial, expansive, and who it sees and serves, and that tension between an older, narrow story of democracy and a broader, more inclusive version is part of what we're witnessing right now. And I think it's important that we begin to have this conversation. And it's not also, we're having this conversation in February, and it's not accidental that we're having this conversation during Black History Month. And I think Black History Month is oftentimes packaged as a celebration, right? The heroes, the milestones. But what often gets softened is the struggle, the strategy, the sacrifice. And so the history of Black political participation, especially in the South, is not a footnote. It is a blueprint. Right? It is the story of people organizing when it was dangerous to organize, litigating when courts were openly hostile. So, redistricting battles are not new, right? The lines have always been contested. And so I think, during this month, I encourage folks to really reflect on what representation really means. And also, I think, Amir, you mentioned the courts might not save us. But I think in moments like this, when the courts feel unpredictable and legal doctrine feels unstable, I think communities can experience confusion and fatigue. Like, people are tired, they're issue fatigued. And so this is why, the way we talk about this, the way the media, reports on this and covers this, it's so important. This is why we have to have narrative clarity in this moment, right? Because narrative clarity does three things. It restores the historical memory. It really reminds communities that, they have navigated hostile terrains before. And that's going to matter. No matter what the ruling is, I think that matters because people, when people lose historical context, every setback can feel final. But when they remember the periods, the long fight, even, even if we received an unfavorable ruling, we keep that radical imagination intact that we've been here before and we can get through this together. Also, the narrative clarity, as I mentioned, just, it's a way to identify, harm, to really help people make sense of this. And that matters. I think when cases and legislation and redistricting efforts move in the same direction, that is not a coincidence. That is strategy. And we have to connect the dots between court decisions, legislative shifts, and community impact. Without that connectivity, or without showing folks that, people experience these changes scattered rather than seeing them as part of this broader strategy to reshape power. And then lastly, I just want to say that having narrative clarity, one of the most important things that I think we just forget, that we have to continue to expand what people think is possible. Like, to remind communities that the courts are just one arena of struggle. They're not the only one. And that matters because, again, when the legal terrain shifts, people, like I said, they can feel powerless, but movements have always operated across multiple arenas. And we have to remind, our communities of that today.
Thank you so much, Anisha. Thank you all, Amir and Mitchell, for that fantastic set of presentations. We're going to move to questions and answers. If folks could put their questions and answers using the Q&A box at the bottom of the Zoom screen while we're waiting for some of those questions to load. I just want to add, this concern about what's about to happen with the Supreme Court is the way this court has been playing chess, playing a game with our rights, basically trying to rig the elections out from under us. And I think that one of the things I would implore the reporters to do is to consider part of the reporting to show what a failure the assumptions of John Roberts were in Shelby. This notion that we've moved beyond, that we don't need the Section 4 and Section 5 of the Voting Rights Act because America has changed. In fact, what we've seen is that his assumptions in that decision were wrong and false. And I think that they were agenda driven by his own hostility to the Voting Rights Act. And then you can see that again in the decisions around redistricting and the maps. That case, I think Mitchell mentioned it and perhaps Amir mentioned it, of the South Carolina NAACP versus Alexander. That's a case where the parties expedited their review to the court so that they could get a ruling before the election started happening. And the court disregarded it. It used its own timing. It chose its own timing so that if it hadn't struck down if it hadn't ruled against the NAACP, that election would have gone forward with maps that a lower court had found to be unconstitutional, or in essence, in violation of the Voting Rights Act. Just like what happened in Alabama, where this Roberts court allowed those maps to be used in the 2022 midterms in a way that had the effect of helping Republicans take control of that House majority. That ruling, going back to the Alexander case, that's a case where that white majority legislature moved 20,000 Black voters out of the first district in South Carolina, where they and their grandparents and uncles and aunts had voted for decades in order to secure Nancy Mace a white majority district. And this Roberts court said that it was okay to move Black voters in order to accomplish a political partisan agenda of enhancing Republican votes. That's the landscape this court has created. And I think that landscape is one of disaster and failure. But as Anisha pointed out, we're going to need to have significant organizing on the ground in response to this decision to encourage people to vote regardless of the unfairness of this decision, and then to use that vote to actually reform and expand voting rights. So let me begin. We've got a first question comes from Maureen Grope, Groppe, or Groppe. It's, can you talk about the timing of the decision? If the Supreme Court issues a decision in the next few weeks that weakens Section 2, how many states would you expect to respond? Or and at what point does a decision come too late for states to redistrict before this year's midterms? Does someone want to take that question? Or any of you, or all of you? Mitchell or Amir or Anisha, you're all on mute.
I say, Amir, do you want to take that one? I guess the second part of the question, I think too late. If it comes out in June, I'm pretty sure that's too late for any state to try to change its maps for the 2026 election. Even if their primaries are in August, the filing deadlines are close to their primaries. And so I think if it comes out in June, like at the end of the session, that's probably too late for any state to do it. If it comes down next week, I'm just not sure how many states would be able to muster that. Amir, you talked about Florida and stuff, so I'm not sure if you have more insight on that.
Yeah, I think that it's all a little bit unpredictable. Every state is different. Every state has different political dynamics. From my perspective, I think the simplest way of thinking about it is if we get a decision after a state has its primary, then I think it's very unlikely that that state will redistrict, because essentially what they would have to do is have candidates who ran in those primaries run again. Candidates generally don't want to run in another election and risk losing. And so I think that to me is kind of the major deadline to look at. When you think about qualifying deadlines, I mean, states can change their qualifying deadlines. Some states already have changed their qualifying deadlines. And so I think that there is still a risk that a state would redistrict if we get a decision, even after a qualifying deadline, but before a primary. And all of the states, obviously have different dates for their primaries. So there are many in March. And so I think if you get a decision after March, it's less likely that a lot of states will redistrict. But the Supreme Court comes back from its winter break on the 20th, a week from today. And I believe, and someone should double check me on this, but I believe they have scheduled the 20th as a decision day. And they've scheduled a couple of days in the week after that as decision days as well. And so there's a possibility that We get a Calais decision as soon as next week, but ultimately, none of us know because we don't know what the Supreme Court's going to decide. We don't know when it will make its decision or what the inner workings of those conferences are like. So it's all a bit of speculation.
Yeah. And
That's
Amir,
right. Oh, go on, Anisha. Sorry.
I did want to add decision day. So yeah, so 20th, 24th, 25th, those are decision days. So
Yeah. Yeah, and I think, I was concerned that the decision would come earlier this year, but I think that the emergency ruling, the shadow docket ruling in the Texas case, sort of sent a signal to states to go forward with the redistricting, even when a lower court had found that there was an effort to exclude Black representation in Texas. They allowed that finding by the court below, which I think included a Trump judge. This court, the Roberts Court, allowed those maps in Texas to go forward, and obviously just recently allowed the California maps to go forward. So the urgency for the broader landscape, I think, is diminished because of those emergency rulings. But the implications of a ruling in Calais could be much farther reaching if the court asserts that it's unconstitutional to have these efforts to not have the Black vote and Black and brown voting be diluted. Because I'm concerned, for example, and here at Court Accountability, that could create a pretext for Mike Johnson and Donald Trump to assert that people should not be seated, who are elected under those long-standing maps or under maps that are prevent the dilution of the vote. And so it's very concerning the way this court, in my view, has manipulated the timing in ways that advance its seeming political objectives to move forward this hostility toward the Voting Rights Act. But we have another question.
And just one thing to add on to that,
Yeah.
Lisa, what we could also potentially see is after a decision, even if it comes too late for a state legislature to act, you could always have private parties file lawsuits challenging previously Section 2 protected districts, like what you see in Calais. White voters challenging a district because they say it discriminates against white voters. Now they would have a citation to a Supreme Court case that says that Section 2 is unconstitutional or weakened in some way. And so you could see that thrown into the mix as well. I think those lawsuits, if there's this doctrine called Purcell that prohibits last minute changes. Well, it used to be last minute, but now the Supreme Court has interpreted that much more broadly, but prohibits changes close to an election with redistricting maps. You would think that doctrine would come into play here, but we don't know exactly how the Supreme Court would handle that.
Yeah. And there's a specific question for you to follow up, Amir, from Maureen. Can you elaborate how Fair Fight Action can fight state efforts to redistrict if the Supreme Court weakens Section 2? What does that look like for your litigation?
Yeah, well, there are a number of different things. And just to be clear, the litigation that I mentioned in DeSoto County, that's being done, that's not a Fair Fight Action litigation that's being done in a separate capacity. But I think there are a number of things that we can still do if we get a decision that got Section 2 and we start seeing state legislatures introducing and trying to get discriminatory maps passed. One, obviously, is advocating against those maps. I think that there is a huge amount of work that we can do to put public pressure on state legislators to try to convince them not to pass discriminatory maps. We saw what public pressure and messaging and communications, the power of that in Indiana, where state legislators there faced a tremendous amount of pressure from the White House to redistrict and get rid of certain seats in their their congressional seats, and they declined to do so, and that effort from the White House failed. I think that you can see similar types of public pressure campaigns happen in other states that try to redistrict after the Calais decision. And then I think the other really important thing is we need to mobilize. The only way that we can really drive that public pressure is to mobilize people to make it clear that what the Supreme Court does if it got Section 2 is unacceptable, that we will not stand for discriminatory maps to be enacted in the various states that might be considering them. And so I think that's another really important part of the strategy if we do get a bad decision in Calais.
Yes, I want to acknowledge that in the chat, there's a comment from Jai Gregory Clark about Article 1, Section 2 of the Constitution and the origin story in terms of the three-fifths, the pernicious, destructive, horrifying three-fifths clause, and more. And I would just note that after the Civil War, as many people know, but I think we've forgotten historically, it was the first time, obviously, that there was Black representation in Congress. The first Black representative was elected to the Senate from South Carolina. There was a tremendous wave of action of people having that franchise, and then there was the betrayal, the by the basically the Hills Taden the part right the Tilden betrayal, where the Reconstruction was stopped. And then we had Jim Crow. We had a whole set of decisions by the U.S. Supreme Court that enabled Jim Crow America. And it was only because of the Voting Rights Act of 1965 that we were able to secure broader representation in Congress and in state bodies across the country, to have real representation, to try to move toward the aspiration of the Constitution's Equal Protection Clause of the 15th Amendment. But there is a question in the chat specifically for you, Mitchell. It is from Lynn Bonner, and it says North Carolina has had a mid-decade redistricting that endangers Black Democrat in Eastern North Carolina. Will there be more effects on North Carolina at the congressional level, or will those changes happen in local elections? In short, what can we expect to see in North Carolina?
Hey, Len, thanks for the question. So the short answer on the congressional level is I don't think that there will be any more effects on the congressional level. The way the map is set up in North Carolina is that the legislature has squeezed out as many Republican districts, I think, as they can, without harming, other fringe districts that may turn into swing districts. And so I don't see any other issues on the congressional level. Maybe in 2030, as we get into new redistricting cycle with new numbers, there may be an attempt to further, entrench power in North Carolina. On the local level, same answer. Unless there is a lawsuit of some sort that challenges majority Black districts or majority Brown districts, as Amir said in his comments, I don't foresee there being a lot of movement on the local level, especially because a lot of these county charters and city charters have within that charter language that they can only redistrict after the decennial census. So they don't have the same authority to mid-decade redistrict that the North Carolina State Legislature has. Now, here's the caveat: if the legislature wants to delve into local politics, which they often do, they could, attempt to try to give the authority to city councils and county commissioners, to redraw districts based on the Cali case. Like that is entirely a possibility. I don't think that's going to happen though. That will require us a lot of resources that would have to be expended to attempt that. I think the real attempt is going to be in 2030, or 2031 when the 2030 census is completed.
Well, we're at the top of the hour. You actually finished exactly on the pin, Mitchell. I want to thank the reporters who've dialed in for this webinar. Please know that happy to help you reach out to Mitchell and Amir and Anisha. Their contact information is in the press advisory, but also if you want to connect with them directly, happy to help and support that. But just don't need to go through us to do that. Please reach out to them with their amazing expertise. Oh, Anisha did have one additional thing to add before we wrap, if you don't mind. Sorry about that. If folks could stay on for just 5 more minutes so we can do a wrap with some additional thoughts and resources from Anisha.
Yeah, just really quickly, I want to be clear. What reporters choose to cover in the next few weeks can either reduce this moment to like this technical court analysis or elevate it into a broader conversation about power and accountability. So in the weeks ahead, I would encourage reporters and the public to watch for 3 things, which is how the decision, is framed, Is it centering communities who are directly impacted by this? It would be super helpful if reporters looked at this in that way, because that's where we apply the public pressure. Break down what the ruling actually changes for voters on the ground. Show that side-by-side comparison of people being shifted, interview directly impacted voters, and then also, I think also making sure that, looking at what states are moving quickly as a result of this, the shifts that are happening. And so get with state-based organizations who can help you track the legislative calendars, the redistricting timelines, examining whether communities are, examining what communities, are impacted. And then also amplifying how organizers respond. That is so important. I think the story is not only the ruling, it is how communities mobilize around it. And that makes me think about the spirit of the civil rights movement, the hope when we saw people marching over the bridge, when we saw people at the protests. And so, reporters and the media and storytellers, you all play a huge role in keeping the public's political imagination going. Thank you.
Thank you so much, Anisha. I'm going to conclude with just acknowledging the tremendous work of that civil rights movement to get the Voting Rights Act passed. Martin Luther King called it a great step forward. He noted that it's a tool and not a goal, and something we have to continue to rally around because of that continuing threat to make it harder for people to vote, which we're seeing in all sorts of ways. We have to toil on. We cannot consider this to be a victory. Clearly, there's been an effort to undo the victories that have been gained. And as Anisha pointed out, here at Court Accountability, we are eager to work with the press along with the public to make sure people are not disempowered but empowered, and recognize the destructive and, in my view, arrogant actions of the Roberts Court to try to rip away these vital tools, and our need to say no, to reject a decision like that, and to organize and respond to restore and expand these vital rights, the right to vote. So thank you all for joining us today. Thank you, Mitchell. Thank you, Amir. Thank you, Anisha. Thank you for our audience. And we look forward to being in touch as we continue to respond to this ongoing crisis by the Supreme Court and by some of the people who are determined to make it harder for people to vote, which we are determined to counter. Thank you so much.
Thanks, everyone.